Thank you to the ELI members for being interested in a tax subject, R&D in particular. I understand that there might be some non-ELI members, and yesterday we had more than 50 registrations for this event. I would also like to thank the European Commission and the European Law Institute, Thomas Dudek in particular, for promoting tax comparison in this specific EU forum. So welcome to this webinar. A webinar that will focus on the ELI European Law Institute study for a European approach to R&D tax incentives. This webinar is addressed to non-tax specialists, to ELI members generally, and will therefore discuss also the issue of tax harmonization in Europe. Harmonization of tax rules is highly discussed nowadays, but harmonization of tax concepts is less. However, before harmonizing tax rules, one needs a common language. Tax concepts have precise meanings. The differences in tax system structures may not necessarily reflect a common understanding. And to test this idea, a European research group selected among the two main tax incentives found in tax system. This research group selected the one relating to research and development, R&D. And at first glance, one could think that R&D concepts were commonly understood. There is indeed the Frascati manual, which is a statistical document providing guidance. It has a huge audience in tax matters, but the research reveals that even in Europe, the R&D tax concept is not shared in its entirety between all member states. This conclusion is the same for R&D tax expenses, which are eligible to the incentive schemes. If one already knew that many differences existed, the project proposes a common approach. And to discuss the result of this research, I have with me three other panelists that I would like to introduce briefly, alphabetically. First, Rémi Barnéou is a guy from Lyon, a Lyonnais guy where I am based, and you can sometimes have next door an R&D tax specialist, and this is the case for Rémi, who is also representing the industry. Rémi has over 20 years of experience in international tax incentive programs for R&D. He held positions in France, Belgium, Croatia, and Canada. He leads multidisciplinary teams of engineers, financial specialists as part of R&D tax credit missions for French and international groups. Despite his many qualities, Rémi is not French, not even European. He graduated from the University of Montreal in physics. So it's so good to have a non-lawyer aboard. So welcome to Rémi and thank you. The second panelist is also familiar with the ELI, Professor Emma Hunt, has been teaching with University College Dublin for the last 17 years. She's also a member of the Irish Association of Law Teachers, the Law Society of England and Wales, and an alumni of the London School of Economics. Emma lectures in international and Irish tax law at undergrad and postgraduate levels. Emma has been part of the ELI team conducting research on this topic. It's a privilege to have Emma Hunt with us today. Last but not least, Johanna Mitroyani from the European Commission. I thank Johanna for her time because she kindly accepted to join the panel despite all the EU urgencies and all other obligations in her capacity of deputy head of unit in the company taxation initiatives. Johanna has also studied in Athens, Greece, and also a PhD from the University of London on corporate taxation. And Johanna is also University of Cambridge graduate. So all the panelists have a truly European experience, reflecting the face of the ELI I now can directly leave the floor to Johanna, who will present the Commission's work in the area and maybe give some background to the audience.
Thank you. Actually, I'm quite happy that I am in a conference talking about a subject I'm not used to. At the beginning, I was a bit reticent, not because I would confuse due to I would refuse due to workload, but because, in fact, in the area of R&D tax incentives in the EU, we haven't done so much. So I was wondering what I would be talking about. But in fact, when one looks a little bit more into this topic, I think there are some points which are worth our reference and perhaps can be let's say, a starting point for doing more in the near future. So compared to other fields of other, let's say, policy areas, we have only very limited action in the field of tax incentives for R&D in the EU. And this is despite the fact that it is recognized that compared to our major trading partners, such as the US, China, the EU actually keeps falling behind in terms of speed in developing R&D and innovation. So in fact, there is a need to enhance R&D. For instance, if I can take a very simple example, hybrid cars and electric cars are very close to us. I mean, in the very near future, we may not be able to travel in the center of some European cities in conventional cars. So I would say that this is just a very evident case where R&D research is very important, and unfortunately it looks like, despite the fact that Europe is an area where there is extensive car manufacturing in this particular field, we may be falling a little bit behind. So now, in an area that I know better than car manufacturing, which is legislation, I mean, I would say that in direct taxation, there is not really hard law, there is no legislation at the EU level which deals with R&D. So one point I would like to make, especially for those who may not be very familiar with EU law, is that in taxation generally, both direct and indirect taxation, decisions in Council are taken by unanimity. And in particular, when it comes to direct taxation, it is necessary in order to be authorized as Commission to legislate, if I can put it in this way, that what we propose involves cross-border activity and contributes to the better functioning of the internal market. It is always necessary to be able to demonstrate also internally within the institution, in order to be allowed to make our proposal, that what we are trying to embark on is there for the better functioning of the internal market, and therefore has a cross-border dimension. So when it comes to R&D, in most cases, it is difficult to demonstrate this very direct cross-border element. Of course, by implication, there are, let's say, cross-border consequences which are linked to R&D, but they are not part of the rule in, let's say, a direct way. So, I mean, on this basis, we would have difficulty to propose legislation on R&D, which may involve, for instance, how a state may give certain deduction for R&D expenses, because this is a measure that is normally limited within the territory, the tax jurisdiction of a single state. In addition, one issue that we have in Council due to the unanimous vote, and we experienced this the only time that we proposed legislation in R&D in 2016, when we proposed something in R&D in the context of a wider corporate tax proposal called the Corporate Consolidated Tax Base. There, because of the unanimity rule, in many cases we have to compromise a lot, and as a result we saw that at the end we ended up having something which was much less in terms of generosity for the business than what individual member states would be able to offer. So that was a disincentive by itself. Now, despite this landscape, we do have some activity in both what is mentioned in the study as input and output incentives in R&D. So what is input? Understand as input incentive is an incentive that contributes to R&D development through the support of the costs. So in relation to this, when the Commission proposed the CCTB in year 2016, we went for a solution which allowed an enhanced deduction for R&D as a business expense. This basically means that with the exception of real estate linked to R&D, we did not capitalize R&D expenses, which would mean that they would then be subject to depreciation, but we would allow R&D expenses to be deducted for tax purposes in the year they are incurred, in the year they happen, and not only at 100%, but even more. And that would be 50% in addition for R&D costs for businesses, for up to 20 million euros. So an additional 50% was allowed for expenses related to R&D up to 20 million euros per year, and an additional 25 for whatever would go beyond the 20 million. And in addition, for startups, this deductibility would be even more generous. It would amount to an additional 100%. So it would be a 200% deduction for tax purposes of R&D expenses in the same year that they are incurred, that they happen. Now, the problem that we had in this, in the context of this initiative, the CCTB, is that it was, so R&D was basically put as an element of the tax base within a broader initiative, which was about a common set of rules, common set to apply across the EU for the calculation of the tax base of companies. Now, the tax base is, for those not familiar with taxation, let's say the amount on which, to which we apply the rate, and then we arrive at the tax liability. The problem was that we were bound to provide for a deduction of an expense. We could not go for the option of a tax credit at the time. And that the reason for this is because the tax credit comes logically in the process of calculating the tax liability after the tax base is known, the rate has been applied, and there is an outcome, how much of tax a company pays, and then comes the credit. And it was found, and it was, I mean, the opinion, our opinion, and the opinion of the Commission Legal Service, that this such a solution would go beyond the scope of the directive. Now, I saw that in the study there is a mention of a CCTB of 2018. So this, I guess, is one of the compromise texts that are accessible on the website of the Council, because there has previously been an access to documents request. So these compromise texts basically arise in the process of negotiations in Council. I should clarify that the CCTB was never agreed in Council. It's just that member states debated it for a good number of years. And in this process of debating, there are several compromise texts. They are called compromise, but that doesn't mean that they attract a real compromise, so the majority of states or a unanimity. And there is a reference to a tax credit. That is not the Commission's, that does not reflect, obviously, the Commission's view of what we can do with the CCTB, but the way decision-making works in the European institutions is that the Commission proposes legislation, then legislation goes to Council, and in the area of tax, the Parliament only has an opinion, and the Council is the only, meaning the Member States, the only decision maker. So Member States decided to move towards a tax credit, and the Commission would have to accept at the end, or say that there is a denaturation of the proposal, and therefore it withdraws it. But that normally does not happen. So this is about, and very quickly, I should also mention that in the area of output incentives, the Commission has done work via the Code of Conduct group, which is a group composed of member states and dealing with harmful tax competition. So the Commission assists this group. And so within the Code of Conduct group, we have
maybe very quickly, Johanna.
Very quickly, yes. We
can maybe discuss that during the question session.
Yes, of course. So I'll just take a minute to say that we have dealt with patent and IP boxes, where actually there is a big risk of tax avoidance when the patent box is not linked to certain conditions. And this issue has to some extent been resolved through the so-called modified nexus approach, which links the low tax of the patent box to, let's say, a condition that the R&D expenditure should have been incurred in the same member state. That's it for me on my side. Perhaps I could just close by saying that for the near future, to the extent we have an agreement at the OECD on the so-called Pillar 2 on the minimum effective tax rate, a lot will change, especially in the area of the output incentives for R&D, because Pillar 2 will have an impact on the attractiveness of patent and IP boxes. Thank you.
Thank you so much, Johanna, for providing the audience with this background, where you mentioned the difficulty for the member states to agree on tax rules, on direct tax rules, tax incentives in particular. You also mentioned the draft tax harmonization project at the EU level, the CCCTB, which had at some point a specific provision for R&D, but with no definition. And Emer, maybe Professor Emer Hunt, the floor is yours to provide the academic standpoint now.
So thank you very much for that. I thought that was very interesting analysis so far. So I guess my interest in this project arose when George asked me to be the Irish National Reporter. And my initial thing was, well, really R&D, you know, that's such a practitioner thing to talk about. And I thought, well, what is the Legal Academy's interest in R&D? Because I had worked when I was a practitioner with lots of accountants and lawyers who knew in great detail what would qualify. And a lot of their expertise lay in the dialogue between the corporate, which was undertaking the R&D, and the national tax authorities. And so often, comparative analysis of tax needs to be justified. And I have come to the realization that it is an incredibly valuable process in itself. So to kind of pursue the metaphor of that box with the light coming out of it, there are many boxes. Nobody agrees on what's coming out of the box. Nobody agrees how the box is made. We have got, as George said, 19 national reports, all of which have a large degree of overlap in the sense that we think we're speaking the same terminology, but when you delve down, you discover that a member state, or indeed any tax jurisdiction, their tax laws are a reflection of their particular ideals and particular social ideals. So there is a very valuable process in actually trying to sit down and work out, what do we mean by R&D? Can we map this process so that at least we're speaking the same language, so that we can identify the disagreements? And that, I think, I'm certainly going to go on and try to persuade you that that leads to an increased transparency, which is a very valuable output in itself. So the rationale, as I see it, for studying jurisdictional R&D, first of all, the concept. What actually do we mean by R&D? I came to it from a common law position, and I remember talking to colleagues on the project and really finding it quite astonishing that they would consider research in the humanities to be something that should gain some type of tax incentive. And that in itself was a very interesting and valuable conversation to have. So what is R&D? Who can carry out R&D? What does it mean to outsource R&D? What are the parameters of that? How, again, do we map that? And then there is something that, apologies to the non-tax lawyers sitting here, but tax is, as I always say to my students, obscenely complex. It's not easy. It's not easy in a national context, but it's also not easy in a cross-border context. So interpreting R&D and the mechanisms whereby we interpret what we mean by R&D, that's also something that as lawyers, we can very usefully contribute to. One of the issues, and I was very interested in what Johanna was talking about in relation to the modified nexus approach, which it has the aim of diminishing tax avoidance in the area of knowledge boxes and other intellectual property exploitation devices, is we can, as lawyers, when we've mapped what people mean by R&D, we can ask, well, are we losing something in transparency? Because we've got a lot of national systems, and the very proliferation of national systems means that we have got a loss of transparency. And the exercise of mapping can serve to elucidate those areas where we have a lack of transparency, or where potentially jurisdictions are in competition with each other from the point of view of R&D. And then the final one there on the left-hand side is the aims of the R&D tax incentives. I think in order to have an interdisciplinary dialogue with our economist or our accounting colleagues, we need to equip them with the terminology. We need to tell them, look, R&D tax incentives, they are a creature of legislation. And in order to discuss them meaningfully, in order to evaluate whether they're useful, we need to do this comparative tax analysis. And again, to take up something that Johanna said, the EU has not legislated in this area. Direct taxes remain a competence of the member states, and indeed, depending on which member state you're in, quite a jealously guarded manifestation of sovereignty. So I think that one has to ask, or certainly an economist would ask, what is the aim of having a tax incentive for R&D? Is it efficient? Does it achieve the purpose? And that type of question, I think, has to be answered in an interdisciplinary mechanism. And I think that the project that the ELI has sponsored and that George has led allows that question to be answered based on a certain clarity of terminology. And I would see the best contribution that we have made is to achieve that mapping exercise over 19 jurisdictions. So the legal analysis of our R&D, leaving aside other specialties or other disciplinary analysis of R&D, I think our aim is to clarify what we meant. I think our aim ultimately is to attempt to draft the parameters. And we did that by talking, first of all, of what each jurisdiction felt the parameters to be, mapping out areas of difficulty. And being lawyers, we always turn our attention to potential disputes. So do we need some mechanism at an EU level for ultimately resolving disputes as to what is meant by R&D and who carries out that R&D? So I felt that the project set the stage for a more informed discussion at an interdisciplinary level. It was a valuable exercise because although we had the Frascati manual, that's not something that is easily translatable into legislation within each member state. And it was that nexus that we needed to examine. And I think that is what George succeeded in this project in doing. So that is the end of my presentation on it. And George, questions at the end or as we go through?
Yes, we'll have the questions at the end of the session. Thank you, Emer. I will now give the floor to myself to present briefly, but a bit more deeply, the ELI study, which is part of a more comprehensive study on aiming at coordinating tax incentive at some point. And let me just share my screen. Because today, as Johanna mentioned, the company can benefit from multiple R&D tax incentives for a unique and single research project. There is a lack of coordination between nations in Europe, but to coordinate tax rules, as emphasized by Emer, we need common language, we need common concept, and building concept is what the ELI was aiming at in providing a common language for R&D tax incentive, which is one of the main two tax incentives in corporate taxation. And as a research project, the methodology was based on a questionnaire, as it is often the case in comparative law. A theoretical framework was set, and a team of national correspondents, 19 national correspondents, mainly tax academics, but also tax judges or practitioners from all over Europe was gathered. And they answered the questionnaire from their national standpoint. They participated in various meetings and advisory committee, including Michael Lang, which was well known from the European Commission, or Robert Danon, who is a R&D tax specialist, was set up. We met in France, in Austria, in Latvia, and I would like to thank also all this extraordinary team for building such a European tax concept. And the primary outcome is 10 principles helping to decide on whether a particular innovative project is R&D for tax purposes, helping to decide on whether a particular expense is or is not eligible to the tax incentive. And as Emmer pointed out, it was considered by the group that R&D is not only test tubes physics, but you can have R&D activities in humanities when you research, for instance, in geography, how to better use public transportation. But the result of the ELI study is more than just these 10 principles. It is a full commentary. It is national reports gathering hundreds of pages of legal and tax literature. And I have a few remaining minutes, so I would like to share with the audience ideas on the project, and we'll try to apply the KISS principle, keep it super simple. Why this project is important, how it is innovative, who the target audience is, and if implemented, what would be the consequences on R&D. First, why the project is important. It is because it deals with research and development, which is one of the 5 targets to sustain economic development of the EU. And R&D expenditure should amount to 3% of the EU's GDP. And how to reach this 3% goal? R&D tax incentives are an appropriate mean. Germany was one of the few countries preferring direct funding for R&D. There was no tax incentive, and the regular German tax system applied to companies active in R&D. Germany, for a long time, did not favor so far tax incentive, but even Germany introduced recently a tax credit as of last year. So the project is a hot topic, and it's a hot topic on an important subject. It is important, but second, how the project is innovative. The project is part of a greater research aiming at coordinating R&D tax incentives within Europe and designing a common European definition. Would payment made to a R&D subcontractor be an eligible expense? Would fundamental research be eligible, or only applied research with a commercial objective? And the 10 principles proposed by the ELI are aimed to be a guidance to decide eligibility of projects, eligibility of these expenses, whether they are considered for a truly European tax incentive or for a domestic tax incentive, because there are so many definitions of eligible tax expenses as there are tax incentives. For instance, a company conducting research in humanities may not claim a tax credit in Ireland, but the same company conducting the same research in another country, France, for instance, would be able to claim a tax credit and thus reduce its tax liability. So the policy underlying this project is the general trend to harmonize tax within Europe, focusing on a particular but crucial tax incentive. There are not so many common tax incentives in Europe. And the innovation of the project mainly resides in providing a shared, a common definition to what is R&D, to what are the eligible expenses. And this is innovative so far as there has not been any such research carried in the past, even by the European Commission. Third, who the target audience is. The target audience is not a particular one. This is the reason why this research would be characterized as oriented by basic research. It aims to help, of course, the European legislator in case an R&D tax incentive is considered, or also for output tax incentive, which are now on the table, and we will need a common definition. It will help maybe the CCTB or the new version of the CCTB called the BEFIT, Business in Europe Framework for Income Taxation. And even if no tax incentive was adopted at the EU level, the ELI project aims at helping national legislators and tax administrations in Europe to have common views. And in the same vein, another category of targeted audience would be the taxpayers themselves. Because if implemented, the project would have consequences on R&D. It will give more certainty to European states' public finance. European states would be more secured in establishing their budget, and R&D is sometimes very important in a state budget. And taxpayers would be more secured in computing their tax credit and thus their tax liability. The consequences have not yet been quantified. This is the job of economists. But the increased tax security is expected to have a significant impact on budgets. Currently, answering the question of what expenses are eligible is a main source of litigation in member states. This uncertainty would be reduced. Now, Rémi Barnéou will provide us the view from the industry. Rémi, the floor is yours.
Thank you, George, and thank you, Emma and Iona, for these very enlightened comments. So I'll, being a partner from a major firm, consulting and law firm, I will then bring the practitioner perspective to this to the ELI study, and it was a real pleasure participating in the study with you guys. I don't know if you can see my screen now. Yes. Okay. So first, I would like to share a couple of questions with you tonight. First question is, why is this European Law Institute study on R&D tax incentive important at this moment? Well, as you know, R&D tax incentive have been around for quite a long time in Europe, since 1983 in France, 1994 in the Netherlands, around 2010 in Belgium, and like George mentioned, the last one being the Germany coming on board the R&D tax credit train last year. But if we look at the graph that you see on your screen provided by the OECD latest report on R&D tax incentive, we can observe that there is a relative stagnation of around 20 EU countries with such a regime. Why a third of the EU countries does not implement such a tax incentive? And if they would develop those incentives, on which basis would they do so? And that's, I think, where the ELI study can be particularly interesting and helpful. Another question we may ask ourselves is, why does EU needs tax incentive policies? That's a legitimate question, and as the process involved in those R&D tax incentive is quite complex for the companies. You know, companies have to identify eligible and non-eligible activities. They have to identify and collect financial data, employee salary, it can be patent expenses, amortization, etc., etc. So it's quite, it's quite complex. And it's also can be very costly for the different governments. For instance, in France, it costs around 6 billion euro a year in the government budget. So it's a very important cost for the government too. And it's also quite difficult to audit. You know, you need to have both scientific and financial or tax audit on a specialist when you do these tax verification on R&D tax incentive. So why do you need to bother with R&D tax incentive? Well, first reason is a competitiveness and attractiveness issue for EU against, for instance, North America or Asia in particular. You know, investor willing to invest money in R&D, well, nowadays they have choice, you know, and they can invest in Europe or they can invest somewhere else. So basically, R&D incentive allows Europe to lower our relatively high corporate tax rate. That's one of the first reasons. And second reason, it allows us, or as European, to lower the most important cost of R&D, which is labor. And when we're talking about, you know, in general terms, between, you know, 70 and 80% of the cost of an R&D project are labor costs. You know, the engineers, the PhDs, the technicians, the different people working on the project. That's the main cost. And as you can see on the graph on this slide, this graph has been prepared by the French National Agency for Research and Technology. And on a yearly basis, they're comparing the price of a researcher in different countries. It's a standardized scale, as you can see, but basically you can see from that graph that the cost of a researcher in France or Italy is almost the same than the price of a researcher or the cost of a researcher in China, thanks to the R&D tax credit, because in those calculations, the different R&D tax credit of different countries has been taken into account. So basically, a French or an Italian researcher is about the same cost than a Chinese researcher, and it's about half the cost of an American researcher. So you see how basically how it can be important, you know, this R&D tax credit. But they're also important for harmonizing the regime across the different country, as George and Emma explained, and to give a better understanding and comparison method for investors. So to reduce these differences, the study first proposed a common definition of R&D, a common definition based on the Frascati manual from OECD and its 5 criteria. So we're talking about novelty, creativity, uncertainty, systematicity, and transferability of the project. But the report put a special emphasis on the novelty criterion, because that's where there's more discrepancy across EU in terms of what do we mean by novelty. And that's the point of principle number 2, where we say that the level of novelty of R&D is considered from the perspective of the publicly available knowledge from a world's perspective. And if you look at the diagram, it's in the little triangle, it's the bottom part of the pyramid. And also from the company proprietary and private knowledge. And whatever is on top of what the company used to do and used to know, and what is known worldwide in the academic or public domain, that's what's considered as a novelty in R&D. So currently, this novelty criterion is verified by different organizations depending on the countries. In France, you have academic experts from the Ministry of Research. In the UK, you have experts from the directly working for the tax administration, etc., etc. But of course, this is subject to interpretation. So we imagine that a unique European body of technical scientific experts could provide expertise and guidance on particular cases or in case of an audit. A bit like what is done by the European Patent Office for patents. So that's one of the principal two recommendation. Another question that can arise is, what kind of R&D incentives should be implemented at the European level? Presently, there are several options, and all these options exist in the different EU countries. You can have refundable or non-refundable R&D tax credit. This R&D tax credit can be based on volume of expense or on incremental expenses compared to previous years. It can be super deduction of R&D expenses from taxable profit as recommended by the CCTB proposal. It can be cash grant, it can be refundable subsidies, etc., etc. If you look at the graph, this is the latest graph coming from the OECD, showing the percentage of GDP spent by the different country through direct funding meaning cash grants, basically, or through tax support or indirect funding, that's the R&D tax credit, or R&D tax super deduction we're talking about. We can see on the little orange bar graph that the EU is around 0.15% of its GDP in terms of financing, and it's quite balanced. You know, it's about 50% tax incentive and 50% direct incentive. But at one end of the spectrum, you got France, which relies heavily on tax incentives, meaning that France and country relying on tax incentive kind of let the market decide what's important to finance. Compared to, let's say, Russia, which is not in the EU, but it has the same level, you know, about 0.4% of GDP in support of R&D. But Russia is focusing more on direct funding and basically saying that, well, the government is directing the fields of research. This is primarily a policy consideration, and the study does not make a recommendation on a preferred method of financing. However, it should be noted that in the original CCTB proposal, a super deduction from taxable profit was included, as Aina reminded us. This can be a very good incentive for profit-making companies, but it is no help for startup or SMEs or other companies which are in a loss-making position in their early years, and we need government support to go through this critical period. Whether the funding from R&D comes from direct or indirect source, what is certain is that funding for a specific project and for a specific company cannot be counted twice. You know, the government, either at EU or national level, won't pay twice for the same expenses. So therefore, our principle number 10 states that any cash grant received for a project shall be deducted from eligible expenses on the year during which these expenses are incurred. So these two principles, number 2 and 10, are just example of what are the practical implementation of what is proposed by the European Law Institute in this study. And we really hope that this work will be useful for the European Union in its reflection on the future of the CCTB, and eventually for different European governments in their preparation of their R&D funding strategy of the future. Thank you.
Thank you, Remy, for this excellent presentation and where you showed that it's tax incentives are also a way to reduce corporate tax rate, high corporate tax rate in some EU countries. I was indeed, it was very clear that French researcher is not more costly than a Chinese researcher. So this is very interesting. Now it's time for the audience to react, and this message is to the audience. You can use the function Q&A for questions, and we have already several questions from the audience, and I think the first question is more addressed maybe to Johanna from Peter Sarek, who's questioning with the lack of agreement between EU member states. Do you think there is any chance for CCTB or the like, or what could be the alternative for unifying tax regulations in the EU?
Thank you, George. So I guess this is a question that goes beyond R&D tax incentives. I'll try to give an answer to this. So first of all, I can say that it has already been announced in the Commission's communication on business taxation, which was adopted on the 18th of May, 18th of last May, that the CCTB, actually both proposals, the one on the tax base and the one on consolidation, will be withdrawn. They will be withdrawn at the point in time when the Commission will make a new proposal for a corporate tax system that better addresses certain aspects that were not as, certain aspects of doing business that were not as evident at the time that the, let's say, a broad reflection was done in the CCTB, and that was between year 2000 and year 2004-2006. A lot has changed ever since, and we need to reflect on several points, in particular how to deal with intangibles, but also on more fundamental aspects such as residence and source in taxation. Of course, this is something that would only be of interest to the tax experts. Is it still a valid distinction given the digitalization of the economy? How can we move ahead? What I can say is that when we look today at what the OECD is doing for the reallocation of profits via formula, perhaps the CCTB was a bit too early. But there are a lot of aspects that we need to consider, and we have already embarked on a, let's say, broad reflection on these issues.
Thank you, Johanna. There is another question in the chat from Chris Morgan. I think it's also directed to you, Johanna. How do you think the ELI study could revive the discussion on tax incentives and on unifying tax regulations in the EU? And I have a follow-up question, which is, now that the European corporate tax rates will be converging, do you think there might be the place for a EU tax credit? Of course, we will need some constitutional or institutional modification, but it is true that so far there is no possibility to a tax credit, but only a super deduction. Okay, but do you see in the future a possibility for a tax credit since the European corporate tax rates are converging. So two questions, the one from Chris and my own question.
So on the question from Chris, I would say that there are 2 points here. One that focuses on the study, which is on R&D, tax incentives, and how that impacts on the CCTB, but then generally another one on tax legislation in the EU beyond R&D. So, I mean, I would say that, of course, the study is a reflection that involves a lot of comparison, and I would say that in this respect, it can be a very good reference, a thorough reference, if there is appetite to move ahead with an initiative. But quite frankly, I would not see an R&D tax initiative in the EU as such. It would have to be part of a more, let's say, general initiative on the corporate tax base or on corporate taxation more generally. And now about the prospects for harmonizing or coordinating tax legislation in Europe. I mean, here again, I would have to mention all the constraints related to unanimity, the fact that there are issues with subsidiarity, meaning that ourselves we can deal with tax matters insofar as they have a cross-border element which affects the functioning of the market. And this is something we have to justify at all steps of the internal process and then also in council. So it is true that the Commission, ever since the beginning of the European communities, always had some corporate tax initiative in creation. There has always been something there. And I also have to say that in some cases, these initiatives have been, when they are discussed in Council, a very effective forum for exchanging ideas, because we see that Member States then, in many cases, took national measures which were inspired from the Commission proposal and adjusted them to their own needs. We have, for instance, examples of member states that introduced national CFC legislation before the Anti-Tax Avoidance Directive, and that was very much inspired from what was in the CCTB proposal. So there is always something there. But I cannot predict to what extent these can be successful in Council. However, I should say that the current initiatives at the OECD, which is an international institution and normally adopted via a global consensus, which requires a political agreement by most member states, because most member states are members of the OECD, create a political precedent on which the Commission can then build to perhaps add certain elements, because if member states have already committed politically at the international level, it is very difficult to take away this political commitment to the extent that the Commission's proposals do not significantly depart from this political agreement. And now just on George's question, building on this, on the, let's say, developments at the OECD, well, I should first of all clarify that the so-called Pillar 2 initiative for the minimum effective tax rate does not mean that member states have to all adopt the same tax rate or the same minimum tax rate. The only thing is that if the effective rate of a certain company in a member state falls below the internationally agreed minimum, then there is a top-up tax that brings it to the minimum. Let's say this is how it works roughly. So, I mean, it is true that the differences between rates become less important. And on this basis, I would agree that there are better prospects for moving ahead with initiatives that may also go as far as tax credits. But then one would also have to see to what extent a tax credit, to what extent we can justify that we need the same tax credit across the EU, and how that plays with the, let's say, elements of the tax system which are behind the ones that are used in determining the tax base, because it's all part of an architecture. So one has to see for each member state the broad picture. So, thank you.
Thank you, Johanna. And perhaps
if I may, maybe, if I may, yeah, just a point on, yeah, on the, I mean, probably agreeing on a common EU R&D tax system would be pretty difficult. But where EU has a lot of power in financing R&D is also in the direct financing. And if you look at the Green Deal, the European Green Deal, where €1 trillion is being invested over the next decade, and the recovery plan with this €2 trillion money invested in different countries, having a huge impact in the investment decision of corporation. That's probably where, you know, imposing a legislation is always tough, but proposing money is always simpler to accept, you know, for the different countries. So I guess that's maybe one aspect of the European influence where on R&D financing, which is not to be neglected.
Yeah, and I would say that another influence by the European Union is actually in grants for universities for academic work in R&D very broadly, and they've got a huge influence there with various funding opportunities. I suppose, Remy, I was fascinated by your slide showing the cost of labor in the various jurisdictions. Now, I actually took a different interpretation than you did from that. And I looked at it and I thought, goodness me, there is a graph which shows that a US labor is vastly more expensive than any EU, but they are vastly more productive in terms of producing R&D. And I suppose that I would, like Johanna, I would actually wonder, what is the aim in seeking a common approach towards R&D within the EU? Because it is such a feature of a vast hinterland. It's a much wider, it's a much wider question than just, oh, let's create the tax architecture for creating innovative and novel. And that's even if we agree about what we mean by novel, which actually we saw we didn't agree what we meant by novel. So I think we need a kind of more transparency as to how the Italian or the French costs have been reduced through R&D. And that, I think, is part of the discussion that the ELI project has started, because we are now even looking at the same graphs, we're looking at the same drafting, we're looking at the same terminology. And I think we can begin to have that conversation, but that conversation has to be had vastly in advance of any aim of saying, look, we need a common system for taxation in relation to R&D. What do you think?
Yeah, that's a good point.
Yeah, because it's a lot of money that we spend. You know, 6 billion is a lot of money for France to spend. And okay, it's brought down the cost of the labor, but what about the productivity? Is it creating the kind of general infrastructure? Is it good value for money? Have we lost transparency? Have we bred an entire environment of people discussing what is meant by R&D rather than doing R&D?
Well, the question is complex because the graph I showed is only the labor cost, I would say, which is just a small part of it, you know. And if we compare to, let's say, the total cost of an R&D project, well, you look at the building cost, the equipment cost, and other, infrastructure or financing cost.
Yeah.
Then the question is broader. But basically, when we're talking about labor cost in Europe, it's not just taxation cost, it's all those social charges cost and all those other costs, which are, much more important than, let's say, the US, for instance. And basically, one of the way we have to compete is to have this overall cost, taxation and labor costs or social charges costs, reduced compared to other jurisdictions, and frankly, the R&D tax credit are a good, are among other things, but are a good point to retain and attract foreign companies in Europe, and
yeah, but at the cost of eroding the tax base, and at the cost of lack of transparency, and at the cost of administrative inconvenience for taxpayers.
Yes.
So I'm not
sure.
saying, I just think
Sure.
all of these things have to be weighed in the balance, which is actually why the project becomes very interesting, because we start trying to articulate the ground rules.
Yeah, of course, and as I mentioned, it's a very costly process for the countries, but also for the company, because it's complex, and and the ELI study is interesting because it's proposing some simplification toward this process, and some European common rules too, because when something is not like George was mentioning, the fact that you have a social, let's say, a project in psychology would be eligible in France and not in Ireland, well, doesn't make a lot of sense, because it's the same scientific project, so there's no rational reason for rejecting in one jurisdiction and not in the other. That's
Except as an expression of that jurisdiction's tax sovereignty and deciding what it wishes to incentivize.
Yes.
Which, it goes back to Johanna's point about, it remaining a member state competence. Look, I think it's a very, very interesting debate, which of course is tied up with the much wider discussion about harmonization.
Thank you. Are there any other questions from the audience? If there will be no more questions, attendees can of course contact the ELI Secretariat, who will pass them to the speakers. But of course, they are invited to ask questions now. So definitely you can see from the discussion, the short exchange, that tax interpretation is difficult. It's already difficult in a national context. It's even more true in an international or European environment. And we may emerge with a European view on R&D, and I think that's where we should aim at, as compared to the US view, for instance, or on R&D, which is already different. So we would like to wish long life to these ELI principles, and long life to the work of the EU Commission on tax harmonization. I think it will help recover from this sanitary crisis, build hospitals, finance new projects. I thank all the speakers and the audience for participating in this event, and thank you all for your attention.